its staff, management, or sponsors.
Welcome to the Ask the Experts show with local experts in the fields of legal, health, financial, and home improvement. Enjoy being educated in such topics as personal injury law, community association law, family law, bankruptcy law, along with health show topics like pain management, men's health, and dental implants. Now, sit back and enjoy today's Ask the Experts with host Steve-O.
Good evening and welcome to another Ask the Experts. I'm your host Steve-O. We're on every Monday and Thursday from 6 to 7. Tonight is our hottest show between all the shows we do. We get more phone calls for this. I'm going to give you the phone number now. It's 888-565-1470. 888-565-1470. Tonight is our Community Association Law Show with Kay Bender-Rimbaum. And we have board certified Robert Kay, who's been with us now for 4 years, and he's going to be with us another year. But it's the greatest, the largest HOA condo association law firm in Florida. For sure the best. Welcome, Robert.
Thank you, Steve.
Kay.
Thank you. Not the largest, but we do our best.
I can say largest, can I? I can.
Only if it's true, and it's not. So.
Okay, so I got. How about the best?
The best is certainly an opinion you can state.
So the phone number here is 888-565-1470. About 25, 30 years ago, when I was living in Dallas, there was a show called Ask the GM. It was on ABC Local, and I got to tell you, I was pinned to that show, and all they did was answer emails the whole time. Well, it wasn't emails. There were letters the whole time. And I said, you know what? We should try that here. And it has been so successful for us getting your emails and texts for questions for Robert and taking your phone calls. So, again, the number here is 888-565-1470. Robert, tell everybody, because we get new listeners every week, tell everybody about Kay Bender-Rimbaum.
Well, thank you, Steve. Kay Bender-Rimbaum is a full-service law firm, but primarily concentrating in the areas of community association law, being condominiums, homeowner association, cooperatives, and we do this out of our offices in Pompano Beach, Palm Beach Gardens, and in Tampa. We're available pretty much throughout the state to assist in association-related matters. We do focus on representing associations as opposed to unit owners who are having issues with the way the board does one thing or another, although we are from time to time assisting unit owners when they try to make themselves and their peers part of the board, and we can certainly assist in those endeavors as well. But we cover all aspects of community association operation, being it reviewing their governing documents, providing assistance by way of advice as to rights and liabilities in their operation, what the board can and cannot do, what owners can and cannot do, contract negotiations, assisting in dealing with lawsuits with respect to construction defects in the contracts that they have, developer-related issues, collection of unpaid assessments, pretty much across the board, everything that a community association may need on a day-to-day basis, that's what we do.
Well, I got to tell you, I've learned over the years now there is so much to know when you're a board member, and you cannot do it yourself. You need a firm like Kay Bender-Rimbaum. Our phone number here is 888-565-1470. You don't have to be a board member to call in. If you've got a question about your condo association or HOA association, give us a call now, and Robert will be more than happy to answer them. Guess we're going to go to our emails, starting off with Barbara in Boca Raton. Boy, we got a lot of questions on this, Robert. Are there new laws regarding opening the pools?
Well, interestingly, it isn't that there's new laws on opening the pools, but the restrictions that had been put in place by the various local governments have been eliminated, basically, meaning that the communities are now called upon themselves to use their best judgment in how to most effectively address whatever their physical situation is to try and maintain as safe of an environment as possible within the community. So the laws that were put in place during the emergency have been basically lifted. The governor last week had pretty much eliminated the ability of the counties to do a lot of the restrictions that they had been doing. I've been seeing a lot of places that they're thinking that the COVID pandemic is over, which is a mistake. People have to still be aware that it does exist. It's still considered a pandemic, and we have to continue to keep our guard up and maintain the proper atmosphere within the community. There was a law that was enacted in Florida that does provide for protection from liability for various entities, and there is some discussion among practitioners whether this applies to community associations or not, because it's geared toward businesses. But I think the majority opinion currently is that it does apply to community associations, but the board still has to use their best judgment with whatever facts and circumstances exist in their community and try and do their best to keep everybody safe.
Okay. Let's go to our first caller, Steve in Sarasota. Good evening, Steve.
Hi. Here's my question. Can a condo board waive interest and penalties on a member's unpaid assessments?
Are you asking, Steve, if in the course of a collection action, a negotiated settlement that might waive late fees and interest that has accrued on the account, or are you talking about in a situation where they're just seeing that they're going to help somebody that they like versus somebody they don't like?
No, it's exactly the first situation you described.
That's a common occurrence.
Negotiate. Excuse me?
I was saying that is a common occurrence in the collection of unpaid assessments. Interest and late fees are generally considered bonuses to the association. While they're required in the documents, they are negotiable, and they don't have to be collected if the board uses its business judgment to decide to waive it under the circumstances, so long as we're not waiving assessments. Assessments can be negotiated on under certain circumstances as well, using business judgment such as the anticipated cost to the association in pursuing and relative to the likelihood of collecting. So that there is some latitude on the board to do some negotiating on that point.
I see. Okay, but there's no real description of those conditions that would allow the actual assessment to be negotiated, right?
Correct. It's on a case-by-case basis, and it's basically the business judgment of the board under the circumstances.
Okay. Well, that's very good. Thank you for answering that question.
Thanks, Steve, for calling.
Thanks, Steve. Thanks for listening.
Okay, bye.
We've got Greg in Boynton Beach. saying, I own a residence. He's both HOA and he has a condo. He wants to know about records. How far can he go back?
Well, the association is required to maintain many of its records for a period of 7 years. So if you try and go back beyond that, the association wouldn't be obligated to have them. So figure 7 years is a good benchmark for him to be considering when he's reviewing the records, assuming he's doing a proper record inspection request.
Okay. Phone number here is 888-565-1470. 888-565-1470. If you've got a question, whether it's HOA or condo association question, give us a call here. Beth in Dania Beach. She says, our bylaws say we have to have committees. The last 2 years, they are using board members to make decisions. Are they allowed to do that? The ARC are making the decisions now. Can those decisions eventually be reversed?
Well, generally speaking, committees are formed to assist the board in completing their duties and typically do not have final decision-making authority. It's more of a recommendation to the board for the board to ultimately make decisions. So if we're talking about an architectural review committee and whether somebody can make an alteration that's on the outside of their home or their unit, and this committee's supposed to consider and approve it, oftentimes communities have difficulty finding individuals who are willing to serve on the committees or individuals who the board feels comfortable serving in that role. And in those instances, the board makes the ultimate determination on its own, and it's generally going to stand. It's not going to be overturned by challenge because they didn't technically follow the bylaws and appoint a specific committee to do whatever it is that the individual is wondering about.
Well, we were told by several people that some of them, I guess, they missed the first half hour when you do your calendar, and they've asked us if we would do it twice. So let's go to the calendar and before we go to break.
That sounds like a good plan. Well, we have several items still to come in the month of May, starting with next Wednesday, May the 12th, Association Leadership Season 2, Episode 15 at 12 noon via Zoom, panel discussion entitled Returning to Normal with Michael Bender, Jeffrey Rembaum, and the Castle Group. On Thursday, May the 13th, a sneak preview at the 2021 legislative update. At 11 o'clock to noon via Zoom, an informational panel discussion with attorneys Allison Hertz and Sean Brown. Basically, whatever has been passed in the legislation this year that's waiting for the governor's signature. Now, the governor has to sign off on these within a set period of time, and generally these new laws will become effective July 1, assuming the governor does. And the session does include a number of bills this year that do apply to community associations, so this is a good one to tune into. There's also on May the 14th, another 2021 Florida legislative session update, this time by Michael Bender as a guest of the Broward Coalition. That's at 10 a.m. to 12 noon on Friday, May the 14th. May 19th, there's a Palm Beach CAM CE breakfast at 7:30 to 10:15 at the Holiday Inn at the Palm Beach Airport. There's a 2021 legal update, which is the changes in the law from 2020. And there's continuing education credits for managers. Peter Mullengarden from the Palm Beach Gardens office will be providing that lecture May the 19th, 7:30 a.m. at the Holiday Inn at the Palm Beach Airport. And then on Thursday, May 20th, very interesting topic, cyberbullying and social media from 12 noon to 1 p.m. Campbell Property Management will be hosting, and it'll feature attorney Sean Brown from our Tampa office. And on Tuesday, May the 25th, the screening process, how to develop procedures and train your screening committee at 12 noon to 1 p.m., a Zoom webinar with continuing education course credits given by Andrew Black from our Pompano Beach office. So those are our planned courses for the month of May. Go to our website at kbrlegal.com, click on the calendar, and then click on whatever event that you want to register for. Pre-registration is recommended. Make sure that we are able to accommodate everybody who wants to participate.
Before we go to break, let's give everybody your phone number and especially your website address.
You can reach us at 800-974-0680, and you can go to kbrlegal.com, or you can write to us at info@kbrlegal.com.
And I got to tell you, your website is so full of just great information. You can spend hours on that website. So we're going to go to break. The number here is 888-565-1470 if you have a question for Robert Kay on HOA Condo Association. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back. This is the first Thursday of the month, which means K. Bender Rembaum. They are our community association law firm. They're with us the first Thursday of each month for the whole hour, 6 to 7. And we have board certified Robert Kay, one of the senior partners with us, answering your questions. If you'd like to give us a call here, it's 888-565-1470. We're also going through, tons of emails. Robert, here's one about a line of credit. Do we have to have a 75% vote for a line to get a line of credit?
Well, that issue is one that's going to be document specific to a particular community. Some communities, the board is able to negotiate loans and borrow money, establish lines of credit on a board vote alone. Some will have requirements of unit owner votes. So you really have to have your documents reviewed by somebody, preferably an attorney who is versed in this area of the law in order to know for sure. Generally speaking, when the board is going to get a line of credit, the lenders usually require that there be an opinion of counsel, which would be the association's attorney, as to whether the procedures they followed are legally correct and whether or not there is a requirement of a vote and whether it's been attained. So that issue is one that should be resolved before the board can get any money, but it's a good thing to know ahead of time before you even start the process.
Okay. Sheila in Hollywood, she wants to know if emails to board members are considered public records.
Well, when you use the term public records in this setting, I'm going to assume you're talking about the official records of the association, which are open to the inspection by unit owners, which is not the same as public. It's a private entity of which the members have certain rights, some of which is to inspect identified records. The issue of emails is one that is often confusing. Generally speaking, if the emails are the personal emails of the board members as opposed to a dedicated email under an association account, then they are not a part of the official records and not open to the inspection by an unit owner of the official records. If the association has a dedicated email address established for the board member, president at abccondo.com, then you would, or president abccondo at yahoo.com would also fall under that category. Then those emails would be part of the official records of the association. Another interesting side part on that is a hired management company of the association also has emails which are the property of the management company, not part of the association's official records. So those emails also are not necessarily open to the inspection of unit owners.
Interesting. I'll bet you this next email, I would bet that they are probably new to the board. His name, this is Cal in Deerfield. He said, I'm on the board and I'm signing all these documents. Do I need independent counsel for that? He's got to be new.
Well, it depends on
like
the
he's a little worried.
You don't necessarily need independent counsel, although if you're worried, you should at least consult with somebody. When you do things in your capacity as a board member, you fall under the umbrella of the association and you have protections that you are given from personal liability for actions you take, so long as you're not acting in willful disregard of laws or in a grossly negligent fashion, or you're not stealing things for yourself. Generally speaking, you're protected from individual personal liability. So, certainly if you're uncomfortable, see your independent personal attorney to get some comfort level, but the association attorney should be able to answer that question as well.
Yes. Let's go to Jack in Boynton. Hello, Jack.
Hey, guys. Thanks for taking my call. Robert, I was wondering, even let's take the pandemic out of the equation. Would a board be able to change their documents to allow meetings to take place via Zoom or something similar? Or is there a piece of legislation out there that would prevent something like that?
That is an issue that has been discussed throughout the state, starting with the emergency situations, and then it seemed to occur to most practitioners that in fact the legislation that's in place does allow for electronic meetings via a Zoom-like platform to take place unless there's something specifically that prohibits it in the governing documents. Yes, the board can present an amendment to the documents to the owners to approve to provide for specific authority to do that, and it's a good idea to do that. In the new legislation that's been adopted this year, there is some changes that have been made to the emergency powers provisions that are now taking into account more than just natural disasters, and have included in the ability to specifically undertake electronic or virtual meetings during an emergency situation as well. I think that many communities have found the benefit of these Zoom-like meetings, that they're more organized, they're more participated with among the owners, and they're able to keep control so people aren't shouting at each other. And they're finding that it's a good way to do business. So I think that's something we're going to see continuing on into the future after the pandemic eases.
Well, all right. Thank you, guys. Keep it up. Good stuff.
Thank
All right.
you.
Thanks for calling.
Robert, I got to tell you, I try to write down everything everybody says on their emails, but people love your show. We get so many people. We had somebody said, how come you can't do it more often? We had a whole board that listens to your show. I mean, you have built up an audience.
Well, that's sweet. But anytime they want to hear more of me, they just can call and hire us, and we're available to talk.
Exactly. Let's go to Terry in Miami. Hi, Terry. Terry?
Hello? Hello?
Yes, we can hear you.
Yes, it's Barry in Miami.
Barry,
regarding
not Terry.
reasonable rules. Hello?
Yes.
Regarding reasonable rules, is it reasonable for an association to have a rule that says that an inspection of official records can only be done by certified mail?
Well, actually, the Division of Condominium has given the opinion that having such a requirement is reasonable and does not consider that to be a violation of any access to records requirements. So as things stand today, that is a reasonable requirement, and the board, if they choose to adopt it, just needs to uniformly follow that.
Okay, but my next question is, written inquiries per the statute, 718, specifically has to be done by certified mail. But there's no such requirement in 718 for an inspection of official records. So would an association be doing, by means of a reasonable rule, something that they couldn't do statutorily?
Well, the statute does not prohibit it, and given that the division is on record as indicating that it's a reasonable rule requirement within a condominium association, then it's generally allowable. There's been no court determination one way or the other on the topic. Typically, if there's going to be any kind of a legal challenge to that rule requirement, it's going to go through arbitration with the division first. And the division is generally ruling that it's reasonable. So somebody has to go through arbitration, get a ruling against them, then go to the court system to challenge the arbitration, still have a ruling against them, and then appeal it to the appellate court, and then get an appellate ruling for there to be clear guidance in the law on that topic. And I think it's very unlikely for us to see that to happen over something such as that, because it's very expensive to
Okay,
do.
I'll tell you what the problem is. A lot of lawyers are saying if you have such a rule, then somebody will have to pay $5. They'll have to go to the post office. They're just not going to request records by certified mail, especially during COVID. And I'm not sure I don't think during COVID it's a reasonable rule.
Well, I'm not sure that COVID has that much of an effect on it, because doing a record inspection during COVID is also a problematic situation because it's a physical, in-person type of situation in relatively close quarters. So a number of communities suspended record inspections where they don't have electronic records that they can provide in that manner because of the pandemic, and I'm not aware of any that have been found to be in violation by the division because of it.
Okay.
As things ease up, I think that we're going to see, obviously a lot more record inspections happening. But as I say, the those that have adopted the certified mail requirement for getting an appointment for record inspections have not had issues, to my knowledge, with the division.
Okay. Thank you very much.
Thank you.
All right, thanks for listening.
I just got an email, text, Robert. Maybe they're not sure about it. There was a ruling that came down in Iowa for a property that was no pet property in Iowa. And this lady was allergic to certain kind of long-haired dogs. And the court sided with her because she was there first. Do you know anything about that?
Yes, there was a federal court decision relatively recently on those facts that you've identified. And this is an issue of where you have competing, for lack of a better term, handicap owners dealing with the same issue. Which one gets the priority in the way the community is run? Because emotional support animals is an exception to a no pet prohibition. And if that woman can show sufficiently, and did show in this case, sufficient basis for her condition and the need for that accommodation, that there be nobody else, and this particular court did side with her. And where that goes from there, it's hard to predict, but it is a helpful answer to the question of how you decide on the issue of which handicap you're going to give priority to, and
Right.
It's along the first come gets the priority.
Okay. We have somebody who wants you to explain the 8-year board term limit.
Okay.
They want to know when it starts.
This is a condominium issue only. In 2018,
Yes.
718 was amended to provide that a board member is limited to 8 consecutive years of service on the board, with some exception to that, such as if he gets a vote of more than 2/3 of the owners, or there isn't enough other candidates to serve on the board, then it could go longer. That began July 1, 2018. So whatever time a board member served before that doesn't count. So starting July 1, 2018, the 8 years began. So until June 30th, 2026, that statutory provision doesn't kick in. This is something else that was attempted to be clarified in the legislation adopted this year that's waiting for the governor's signature.
Okay. Here's somebody from your office neck of the woods, Cindy in Pompano. I guess she is on the board of, by the way, that's thunder in the background. She's on the board, an HOA. She's head of their compliance committee. One of their, I don't know what this is, one of our ACC was defamed by another member. The person wants an apology because there were 60 people on the call. Our committee is going to get this. The lady who defamed wants an apology. What should we do? Should our committee even get involved?
Well, ACC is Architectural Control Committee, so it's
Okay.
like same with the review board. The defaming is a difficult issue, and it's one that generally does not involve the association because it's a personal issue to the individual who is allegedly been defamed. It would be necessary to know precisely what was said, whether or not it was actionable. Generally speaking, in order to have any kind of legal entitlement to pursue a claim of defamation, there's going to have to be some kind of damages beyond her feelings. There's got to be some form of financial damages, unless the allegation was one of criminal conduct. You know, if you say you stole a bunch of money from the association, well, then you don't need the damages because that's considered a per se violation, and then the court will decide a dollar figure to attribute it to it.